Welcome to the Property Buyble. This show was created for current property owners, people looking to purchase property, and for professionals in the industry. Hope you enjoy. Welcome back to the Property Buyble. My name is Kim Ackerman. I'm a buyer's agent from Trelease Associates in Sydney. Now, today we're going to be doing part 3 of our pre-purchase due diligence series. We started it a few months back. We started going through things like pests and building reports. We've gone through extensions and alterations with an architect that I work with. And today we're going to be going through the third and one of the most important parts of due diligence, and that is the review of the contract of sale. So to help introduce this topic, I have Renee Roumanos. Welcome.
Thank you.
Renee works for Fazzini lawyers in Sydney, and you specialise in conveyancing. So what better person to help me go through this topic?
I'm happy to be here. Thank you.
So I guess when we talk about the contract of sale review, and look, we're in New South Wales, so we're mostly going to be referring to a lot of New South Wales legislation and the New South Wales contracts of sale as well. Yeah. But we're talking about residential properties, mostly homes that we're buying for clients and so forth. So what is a contract of sale?
To be put simply, it is the legal document that sets out the rights and the obligations of the purchase.
Okay. So it's a binding obligation. It's a binding written document between the purchaser and the seller.
Correct. It includes all the mandatory documents that must be in a contract for sale, such as the title search, a planning certificate, sewer diagrams, and various other documents.
Yeah. And it's going to include all of those special conditions and anything that the vendor basically wants to put in place that the buyer is agreeing to as well.
That's right.
In most cases. Okay. And when we go through the contract of sale, generally what happens, obviously they agree on an offer, so on and so forth. The purchaser signs and the seller signs as well. Now, when is a contract legally binding?
A contract becomes legally binding when the purchaser has signed, the seller has signed, a deposit has been paid, and finally, upon the cessation of a cooling off period. Or in some cases, if they waive their right to a cooling off period at that point.
Okay. So for a lot of people listening that, don't know a lot about cooling off periods and exchanges and things like that, we're basically talking about people agreeing on an offer between the purchaser and the seller, or the buyer's agent and the selling agent in that case, signing the contract, paying a deposit, and it exchanges.
That's right.
So there's 2 types of exchanges we're working with, isn't there?
Yes.
What are those 2 types?
So the first type is when what's called a Section 66W certificate is signed, and that is when the purchaser waives their right to a cooling off period. And there are many circumstances where that would become a really attractive offer to a seller. And then the second type is when there is a cooling off period, which is sometimes 5 days or 10 days, depending on what's negotiated upon. And usually that suits people who still need to get things like a building and pest inspection, or still need to obtain finance, or need to obtain a valuation on the property to ensure it's within their conditions.
Yeah.
So in those circumstances, if there's a cooling off period, there's always still an opportunity for that purchaser to rescind the contract if they decide they don't want to go ahead.
Okay. All right. So we've got unconditional and conditional, basically. With the unconditional, it's done, it's dusted, there's no calling off days whatsoever, you're locked in.
That's right.
And that's when those settlement days start. So typically around 42 days?
Yeah, that's right. Typically it's 42 days.
Okay.
There is always an opportunity to negotiate. And again, that's why it's so important that purchasers speak to their solicitors prior to entering into these contracts. Because if you sign on the dotted line and the contract says 42 days, you're bound by that 42 days.
And that's when that clock starts ticking,
that's
basically.
Right.
So 42 days from that point onwards, if that's what's been agreed, you've got your settlement day.
Yes.
Which is when we collect the keys and everyone's happy.
And the money is paid, of course.
The money's paid, all of that is done, the banks are settled and everything's finalised by that point.
That's right.
Before we get to that, we obviously need to review the contract of sale, and someone like you will step in for these purchases. And as a solicitor, you will review them on a professional basis, and you're going to know exactly what you're looking for.
Absolutely.
So if, we've worked together on many deals before.
Yes.
as I send you a contract of sale, typically, we get the contract of sale from the selling agent and then I pass it on to you and you start that review process.
Yeah.
What are some of the common things you look for or you normally find in a standard contract of sale?
With every contract, it's a little bit different.
Yeah.
But and it's always about looking at that contract and ensuring it meets the needs of the purchaser. There are some purchasers that say, I need vacant possession because I need to move in. But that contract shows that there are tenants in the properties.
Yeah.
So it's about giving that advice to the purchaser. But some other things that I would find really important to go through is just the first and most foremost, the title search. Having a look at the title search, checking if there are any caveats or easements or any unregistered dealings, and having an opportunity to advise the client on what that may be and what that means for them.
Yeah.
Secondly, will always be the planning certificate and what's happening in council, whether there are any restrictions on that particular property, whether that particular property is prone to bushfires or flooding or anything like that, and what that means for that purchaser. Because purchasers might not understand what a bushfire-prone land could mean for them, and it could actually mean substantially higher insurance policies on that particular property. And then, of course, the most important, the special conditions.
Yeah.
Special conditions are generally prepared in favour of the seller.
Yeah. Well, the whole contract is, right?
That's right. Absolutely.
It's prepared by the seller's lawyer.
Correct.
And it's up to us to try and make it a little bit more
favourable to our
even
purchasers.
playing ground. Absolutely.
That's right. So when I look at the special conditions and I go through them, there will be so many conditions in there about the purchaser breaching the contract, or if the purchaser doesn't settle by the settlement date. And what people don't realise is the severe consequences. And I'm not talking $5. I could be talking about $5,000.
Yeah.
And that's a lot of money when you've already paid, massive amounts. We're in Sydney, so massive amounts of money for a property.
Yes.
So it's about taking those special conditions and negotiating them to be a little bit more reasonable, obviously in line with today's market, and reducing things like the penalty interest. Most contracts have a 10% penalty interest, and that's quite high. That could mean $400-500 per day that you're late in settling on a, say, $2 million property.
Yeah.
So reducing those to 5% rather than a 10% is just a little bit more in favour of the purchaser, and it still protects the seller. Which,
for sure.
So in line with both parties.
It's really just mitigating the risk.
Absolutely. I couldn't have said it better myself. Reducing the risk, ensuring that whatever's in the contract benefits both parties, because that's what we need. We need an even playing ground. And I just think it's so important that if someone is going to sign that contract, they need to understand what that contract means.
Yeah, for sure.
And who better to do it than, a solicitor? That's the person you want looking after you and assisting you in that process. And looking at the contract from page 1 to page 200 in some cases, and going through and giving you the full advice around what it means, what all the terms and conditions are, and what the risks are in relation to that particular property.
For sure. And it's having someone on your side legally representing you, the vendor solicitor or the seller solicitor that's prepared that contract is not representing the buyer in any way. They don't have their interests at heart in any way. It's purely for the seller. So it's really important to go through these contracts just to plan for really worst case scenario.
Absolutely.
Should everything go wrong, everything goes to shit. Imagine like the settlement doesn't fall on the right day, the bank's taking forever, you start getting charged interest by the vendor, solicitor, all these sorts of things could happen. You want to try and just cut down those things as best and make the environment as best as possible.
Yeah, absolutely.
For you as a purchaser.
And as a solicitor, who better to negotiate on your behalf and assist the purchaser? So if things, as you said, turn to shit, you want someone that knows how to negotiate and knows how to even the playing field a little bit, because there are so many times where things go wrong, but they're outside of the purchaser's control.
Yeah.
For example, snap lockdown in Sydney. People couldn't sign loan documents and take them to a bank. That could have caused delays.
Yeah.
So it's about having the right person in your corner who could fight a little bit so that if something happens and it is outside your control, we can mitigate the losses a little bit and try and even the playing ground.
Yeah. So I guess just to break it down and sort of unpack that a little bit, we get these contracts, someone like yourself, a solicitor or conveyancer, checks the contracts, says, I think we should change clause 5, 6, 7, 8, whatever the case may be, to make it more in favor of yourself as the buyer. Those changes get sent over to the other side, and we basically say, these are the things we would like to change to make it more of a even playing ground.
Yep.
Do you agree? Don't you agree? And you sort of go back and forth until we have a final version of the contract.
Yes.
Now, 3 different buyers might have 3 different versions of the contract depending on what they've negotiated as well.
That's right.
So it's about having someone who has done this 10 million times, who knows what are the things that we should look for and what are the things that we should ask and what are quite common to change as well. Okay, so there's so many different things to do with the contract of sale, and depending on what type of contract of sale we're getting as well, we're going through this process. I mean, there's situations where there are pools in properties that we're buying, houses, for example, and there's a whole nother area of
Absolutely.
pool compliance, for example, to look at.
And again, another reason why it's so important to have a contract reviewed. For example, if there is a non-compliant pool certificate, I don't think purchasers realise the severity of that.
Yeah.
By law, they have 90 days to rectify any issues with a non-compliant pool.
Yeah.
And should they not rectify that within 90 days, the purchaser can risk a substantial fine from council. So that's, again, just one of the simple reasons why it's so important to have a contract looked at from A to Z and understand every single aspect in that contract.
It's to save issues. It's to save money.
That's right.
And that's what it really comes down to at the end, time and money, and getting into that home or into that investment that you've been hanging out for. So look, let's give people some tips on, little things that they can do along the way when they are getting a contract of sale review during this time. I think, one of the big things is, look, I work with a lot of different solicitors, conveyancers and so forth, depending on the clients and who they have behind them as well.
Yeah.
But what I find is that a lot of solicitors or conveyancers, they may not charge for the first few reviews, especially if you're unsuccessful. You do that as well.
Absolutely.
When you go through that process.
I look after my people, and I think it's so important that the solicitor or conveyancer absolutely do, looking after the people that we're looking after, because we win some and we lose some.
Yeah.
As you know, the property market is crazy.
I definitely win some and lose some, that's for sure.
That's right. And there are sometimes we look at contracts and we can advise and negotiate terms and move forward, but that might be the one the purchaser really wanted. So it's a bit of a slap getting a slap with an invoice if they didn't get it.
Yeah.
So I think it's really nice for a solicitor just to be a little bit more human.
Yeah.
And doing the first one complimentary or the first few complimentary, and I'm all for that.
And it's all about just really like knowing in advance, I guess you'd say. So if people are speaking with a solicitor or a conveyancer and they're looking to engage with those people, just ask what their payment terms are.
Absolutely.
Will you charge if I miss out on 1 or 2 properties? Most people don't charge for the first 1 or 2, but just find out before you engage with anyone.
Absolutely.
And you can continue on from there. The next one, which is a biggie, which we talk about a lot, is I guess the difference between a solicitor and a conveyancer. So there's a couple of key differences.
Absolutely. So a conveyancer is great, but they strictly deal with the purchase and the sale of the transaction.
Yeah, absolutely.
Right. So they look at that simple transaction. In addition, is if there is a contract that's high risk, if there is a purchaser that's high risk, if there is an issue that comes up, the person you want in your corner is a solicitor, because they can handle issues. They can commence legal proceedings.
Yeah.
They can give a sound, broad range of legal advice. So in my opinion, of course, I will say that you want a solicitor, as a solicitor, you want a solicitor in your corner assisting you from start to finish, because if something does come up,
you don't have to get a third party in.
That's right. And they're with you start to finish.
Yeah.
And most of the time, we don't just buy property. We do various things in our lives. We're going to need a will after we have the property.
Yeah.
And you'd want the same person helping you, because that person knows your property. That person knows you've got 2 kids and you've got this and you've got that, and they're already in your life. So it's really good to have that one person who can assist with various areas, not just that simple property transaction.
Yeah. So I guess just to put it very straightforwardly, conveyancers do a fantastic job at conveyancing, and that's what they're hired for. But anything outside of that conveyancing or that contract of sale review, they can't actually legally give legal advice.
That's right.
So if a problem was to arise that branched off from that transaction or that purchase, most cases a solicitor or a lawyer would have to be brought in separately to deal with that issue.
That's right.
The conveyancer, which is not ideal, but everyone's different, and either party will ensure that that contract of sale is reviewed adequately so that they can get the deal done at the end of the day.
That's right.
The next big one that I wanted to mention is the deposit situation.
Yes.
We get a lot of questions about this, and this is a really big thing. So on the front of a contract, we've got 10% deposit is due upon exchange.
Yes.
So when both parties are signing the contract, 10% is due when the contract goes unconditional at that point. Now, sometimes you negotiate 5% or even less in some cases. However, what a lot of people don't know is if something was to go wrong. So generally speaking, if that purchaser paid their 5%, for example, and they decided
to pull out.
Because
they couldn't proceed. And it happens.
What would happen?
They'll get sued for the other 5% that they hadn't already paid.
So this is a thing. The full 10% is still due. You'll not only lose your 5% in most cases.
Yes.
They will then claw back the other 5%, which is the full 10% on the contract.
That's right.
So even if you've negotiated 5%, 10% still stays on the front page.
That's right.
Yeah.
And that is why they always say, happy to agree to a 5% deposit, but the other 5 will always be due on completion. So people need to understand you always need that other 5% should something go wrong.
Yeah. Have you ever, because I've seen contracts before where they've agreed on 5% and only 5% and they've actually physically changed the front of the contract. Have you ever been in a situation like that?
Yeah, it does happen, but by law, 10% deposit is what is required.
Yeah.
And that is why, regardless of the negotiations that occur, the front page will always typically say 10%.
And most people, to be honest, I mean, this happens with a lot of clients that I work with all the time. They want 5% because what happens with that 5% deposit is it normally just sits in a sales agent's trust.
That's right.
Doesn't earn any interest most of the time. Sometimes it does.
Yeah.
Doesn't earn any interest. It just sits there and basically waits for those 42 days to pass.
That's right.
And then the seller gets that deposit and the rest of the money along with it.
Correct.
Whereas if you can negotiate down to 5%, you can maybe potentially have another 5% earning interest in your own account.
Yeah, absolutely. On the note of a deposit, it is, I think, really important to acknowledge that there are contracts that specify in their special conditions that the seller can release that deposit only for the purpose of buying another property for that deposit.
I see this all the time.
And it happens. And it happens all the time. So sometimes the deposit will sit in a trust account and other times the seller will grab that deposit and spend it.
Yeah.
But the risk in that transaction is if something happens to that house prior to completion, the deposit's gone. And it's actually, technically it's the deposit for the purchaser until completion.
Yeah.
So it could raise some interesting legal questions.
How do you feel about the release of deposit clause? Do you normally encourage people to try to get it removed? Or really depends?
It just depends. Every situation's different. I have to say, in my special conditions for my seller's contracts, it's always in there.
Yeah.
It's generally in there if they want it.
Yeah.
But if people negotiate it out and I know that purchaser doesn't need it, it's something we can negotiate on. But every situation's different and it's all about protecting our seller, protecting our purchaser and finding some happy medium.
Yeah. And some of them need that release of deposit clause to get their next property. Like it's not even a negotiable item
Absolutely,
at that point. So I think it's just about talking with both sides and working out what's fair, what both people are comfortable doing as well, and just what kind of risk they're taking on by allowing them access to that 5%, the release of deposit prior to the settlement day.
Yeah.
So sometimes in cases like that, when someone is wanting a release of deposit, which I've seen so many times through buyers and sellers, it's usually because they want to use that full 10%. If they don't agree to a 5% or even less, sometimes you've negotiated 4%, I know in the past, and even less sometimes. But if they don't agree to that, it's usually because they physically need that money to put towards the deposit of another property before they sell this one.
That's right.
That's what I find.
That's right.
Anyway, but we could talk all day about this. This is a great topic and this is done every single time on every single purchase. So it's really important for people to just be aware of what all this jargon is, what are the things to look out for. I've got plenty of clients that pick up a contract of sale and try to have a read through it and just want to see what are the things they should be aware of. So it's good to just know those things, but I always encourage, get somebody to review your contract, conveyancer, solicitor, whoever you have on your side.
Absolutely. And it's understanding the contract, understanding the risks, understanding and interpreting what that actually means. Looking at something and actually being able to understand what that actually means for them. So important.
So important. So get it done. It's part 3 of your due diligence. There are other due diligence items we need to go through, but this is a really important part of what you go through before you buy a property. So thank you for joining us today.
Thank you for having me.
Loved having you. I've been waiting to have you on the show for so long now, almost a year. But so excited, so glad that we could touch on those things. I'm sure we'll be doing many more topics together, but hope everybody has learned a couple of things about pre-purchase due diligence, contract of sale review. Join us for the next topic coming up on the Property Buyble, and we'll see you soon.